Hi, it's Ron Coleman. Welcome to everything you ever wanted to know about lawyers, but were afraid to ask. It's Ron Coleman. I threatened that in this segment we would talk a little bit about what kinds of civil discovery are available in a lawsuit. And the reason you might find it interesting is because you'll see, if you are on social media as I am, if you're on Twitter as I am, you'll often see when people talk about lawsuits, tweets that say, well, they're not going to want to give discovery in this case, or let's see what discovery turns up in this case. So it's probably a good idea to understand what that means. I'm talking about civil cases. The amount of discovery, and what discovery means in general, is pretrial exchange of information. The amount of discovery available in criminal cases is very, very limited. But I don't practice criminal law. I'm not going to talk about that. I'm going to talk, however, about civil discovery, which is a very, very big part of the work that litigators, whether they are really trial lawyers who try cases or not, do. Very few of us are in court every day. So, just pardon me as we turn off the ringer. Do you like the real life feel of this yet? Okay. I talked a lot about documents last time. As a general rule, Rule 26, and I'm going to talk about the federal rules of civil procedure. Most states' procedures either track these rules or are essentially the same. So although there are two parallel court systems, the federal and state systems, I hope I don't have to explain that. If I do, then that's something you should let me know in the comments, and we'll talk about that some other time. But under Rule 26, the scope of discovery is very, very broad. This is one of the reasons foreign companies hate American litigation, because the premise of American discovery since after World War II has been that each side is obligated to let the other side know any facts that are not privileged. Privileged means basically only that it's between a lawyer and its client. Sometimes there's a confidentiality protection, but very seldom in these cases. Whatever information you have available to you in your custody or control, either you have it or you can get it reasonably easily, you have to give to the other side if it bears on the case based on their requests to you. Each side makes requests to the other side for documents that would be that would be relevant to either to the case or to the defenses, so that nobody at trial should be surprised by a smoking gun, so-called, or otherwise, or any kind of other document. Everyone should know going in what the facts are that we're going to be trying this case based on. Those are elicited by document requests, or requests for documents. Sometimes they're also called document demands, which is probably more appropriate because they're not really requests. Requests is just a sort of politesse, sort of simulated politeness. You're not really asking, you are demanding that the other side give you the documents. You serve the document request, the other side has 30 days to produce them. That is a deadline that is far more observed, unfortunately, or fortunately, depending on your perspective, in the breach than in the observance. 30 days to produce the documents. In other words, you'd give me the list of documents that you think I have, and that or categories of documents that you might think that I have that could be relevant to proving the case. I then have 30 days to either find those documents or object to the document request as either requesting information that is not likely to lead to admissible evidence. In other words, the documents themselves don't have to be admissible, but they can still be information that could lead to admissible evidence. So what does that mean? There's almost no reason on earth that a company phone directory would be relevant in a commercial litigation case. But if I wanted to know the names of everyone who was working in a certain office at a certain date, I might ask you for all company directories from June 2018 through December 2018 to find out who was on that directory. Then I can depose those people, or I can ask questions about those people and other forms of discovery. That, therefore, is valid discovery. Discovery requests can be overly broad, or they can be overly burdensome. There are all kinds of objections to discovery requests, and a lot of the time that is spent on discovery requests, in pretrial procedure is fighting over document reviews. How much is each side going to provide to the other side? Not only what documents, but what forms of them. This has become very relevant in the era of e-discovery because there is potentially a lot of importance placed on what's called metadata, which in the case of electronic documents means when was this document created, when was it modified, who modified it, what machine was it done on, what's on all the hard drives, the extent to which parties and adversaries are expected, allowed, entitled to drill down on that depends on the nature of the case. So if the case involves, such as one that I was busy with for many, many years and which finally came to an end last year, we won the appeal. If it involves a fired police officer deleting data from the police department's computer that he was assigned to, so then you're going to have a lot of forensic analysis of the data on that hard drive and on his hard drive and his flash drives and his other portable media. On the other hand, if it's a routine commercial case involving, few disputed facts, but maybe a legal dispute over what a contract clause means or who paid what when, you're not going to be involved with so much metadata. So it really depends. E-discovery is a gigantic field. In some respects, it has made the review of documents easier because instead of taking a bunch of junior lawyers and putting them in a conference room and having them look at boxes and boxes of documents and trying to match up duplicates and distinguish among possible duplicates because this one has marginal notes on it or this one was found in the file of this executive, whereas this one didn't have it, and why didn't he have it? And these are facts that might be relevant depending on the nature of the case. With e-discovery, you don't have that physical, paper business. You do have often dueling experts on the topic of the electronic or digital history of someone's media. And what you're all asking me right now, what you're all wondering is, how do I know the other side's going to give me what they have? How do I know they're not going to delete stuff? How do I know that they're going to turn over the flash drives or the personal files? And the answer is, you don't really know. You do know that there are very severe penalties for destroying information in litigation unless you are the government or Hillary Clinton, someone who bears no accountability, risks no accountability whatsoever for his conduct. But for most people and for anyone that any good lawyer will be advising, and by good I include ethical, it's even if I thought it were a good idea for you to unethically destroy data or destroy a document, it would almost never be my advice that you do so, not only because I'm an ethical attorney, but because I know that you're very, very likely to get caught, either by forensic examination that usually can show that something has been deleted, and often what you think was deleted wasn't deleted at all. Or I can show that the email that you didn't produce and that you think you deleted shows up on someone else's server or on a backup file. And then you've got a bigger, or in some other recipient's inbox. Then you've got a bigger problem than you would have had if you had not deleted it. Because A, now we have the email, and B, now we have a very strong presumption that you deleted it, which is it's called spoliation, not spoliation. Spoliation, and you can have your entire case dismissed because of spoliation. If I advise you to delete documents, or if I'm aware that you're deleting documents that are supposed to be produced in discovery, I could be disciplined and potentially even disbarred. It happens anyway. It happens anyway, just as people lie under oath all the time. We'll talk about that when we do our next segment on depositions. But first, this is the core of paper discovery is the document production. Each side, again, asks the other side for what they believe will be the relevant documents. You're actually obligated to do what's called an initial disclosure of documents that you think might be relevant. This is kind of a pro forma process because you're allowed to identify them as well as merely identifying them instead of producing them. So we usually just identify them. All the documents we have in this place and all the documents we have in this subject. So it's not really the pretrial voluntary disclosures are not all that big of a deal when it comes to documents. But documents are a big deal. An important part of every case. Except for the simplest cases, corporate litigators spend years and years in big corporate cases dealing with document review issues, because I'm just talking about organizing, categorizing, deciding which documents are relevant or potentially relevant, or which might turn out later to be relevant, or might be what we call hot documents, like these are the smoking guns, or the ones that the other side are going to find to be smoking guns against our clients. How are we going to defend against them? And from here, we shift into the process of the analytical process of figuring out what to do, how this document helps our case. And that will be coordinated with the process of using the other tools of civil discovery, oral depositions, requests for examinations, requests for admissions. We'll talk about those in further segments. So I think 13 minutes on document production is just about enough. So I thank you very much for joining me today, and I hope you get a chance to do this for a long time so that you'll be able to understand all this stuff. And we'll be talking about the same thing next time we see a tweet that says, oh, I wonder what discovery is going to show in this case. We're going to discover the whole expensive, time-consuming, aggravating story. So long. Talk to you soon. Thank you for watching and for your patience as I work out how I'm going to do this on YouTube. If you want to see the next segment where we'll explain a little bit more about what I talked about today, subscribe and you'll know when it's uploaded. I appreciate your interest.